Good evening. My name is Susan Moon, and I'm the Executive Director for the Walnut Creek Library Foundation. The Walnut Creek Library Foundation raises funds to provide free programs, purchase equipment and supplies, and add to the collections for our two Walnut Creek libraries. I'd like to thank our Finance 101 series sponsors, Kathy and Jerry Hicks, for making these programs possible. Thank you for joining us for our third program in our Finance 101 series, Medi-Cal Eligibility Rules and Special Needs Planning Basics. Tonight, our presenter will discuss Medi-Cal Planning and Special Needs Trusts. These topics are useful for all families that have aging family members and those that have special needs. Our last program on April 22nd will wrap up the series with a deep dive into Social Security and Medicare. I'm pleased to introduce Kirsten Howe of the law firm Absolute Trust Counsel. Kirsten has been in the law business for over 20 years, specializing in estate planning, trust administration, probate, and taking on Medi-Cal planning and special needs planning and trusts as well. She's been a presenter in our Finance 101 series for several years, and we are delighted to have her with us again. She graduated from the Hastings College of Law, University of California, after securing a BS degree in biology from the University of Michigan. She's also a member of the Trust and Estate section of the California State Bar and Estate Planning and Probate, Elder Law, and Women's sections of the Contra Costa County Bar Association. She also serves on the board of directors of the Estate Planning Council for Diablo Valley. Tonight's program will be in two parts. After the Medi-Cal presentation, we will have a brief Q&A and then proceed with the special needs planning basics, followed by a brief Q&A. And feel free to submit your questions in the Q&A box below at any time. Without further ado, please welcome Kirsten Howe. Hi, Kirsten.
Hi, thank you, Susan, for that lovely introduction. I have done, as you said, I've done this presentation for a few years now for the library, and this year we decided to add to the Medi-Cal presentation and do a short segment on special needs planning. And what those two areas have in common is that we are doing planning to help disabled people. One thing I want to clarify from the beginning is that Medi-Cal is a lot of different things. Medi-Cal can be health insurance for people of low income. There are many different Medi-Cal programs, but the programs that we're focusing on tonight in the Medi-Cal eligibility planning is Medi-Cal for long-term care for disabled people over the age of 65. That's going to be the first part of the presentation. And the second part is focusing on disabled people who aren't over 65 and aren't in nursing homes. So I will, I'm just going to apologize up front because the technology might flummox me, but I'm going to do my very best and hopefully I won't mess it up too badly. So I'm going to start with the first half. It'll be a little more than half actually, but the Medi-Cal component. And Medi-Cal is just such a complicated area, and there are many, many misconceptions. People make mistakes all the time because they just don't know what they're supposed to do. They don't understand it. And sometimes those mistakes cost money. And sometimes they cost a lot of money. And we will talk about some of those mistakes. Here tonight, I'm not here to teach you how to do Medi-Cal eligibility planning. As I said, it's very complicated. If you need to do Medi-Cal eligibility planning, you need to hire an attorney who is very familiar with this area of the law. What I'm here to do tonight is to expose you to this area of the law, give you enough information so that you know what to look for, you know when to call an attorney, you understand what that attorney is talking about and what that attorney is advising you to do. So I'm just giving you enough information to be useful and protect yourselves. And the way, my method, the way I'm going to cover the material is I'm going to walk you through a lot of the misconceptions that we deal with commonly when people come in to talk to us about Medi-Cal planning. And by sharing those misconceptions and a few other concepts with you, you will understand what you need to know about Medi-Cal to avoid making any mistakes and to plan correctly for your family. So my first and probably one of the most common misconceptions that we encounter when we are speaking to clients is the misunderstanding about the difference between Medi-Cal and Medicare and what they pay for. And one of, I wish I had $1 for every time I asked a client this question and they came up with this very answer. The question is, do you have long-term care insurance? And the answer is, oh, I don't need that because I'm over 65 and I have Medicare now. And that is such a common misconception that Medicare will pay for nursing home care. Medicare does pay for nursing home care in certain instances. And so it's understandable why people have that confusion. So I just want to clarify this for you. They're in nursing homes. There are two kinds of people. There are the people who have been to the hospital because they were sick, because they were injured, they had a stroke, they had a heart attack, they've been to the hospital, and now the hospital wants to get rid of them. Hospitals don't want you to be there for very long, but usually after a major event like that, you're not well enough to go home, but you need to leave the hospital. And so this whole industry of skilled nursing facilities, what we call nursing homes, has developed to receive people who they can't stay in the hospital, they're not that sick anymore, but they really aren't well enough to go home. And so sometimes we call those rehab facilities. So in nursing homes, there is a whole population of people who are there just temporarily while they are rehabbing from having been in the hospital. And then the other population there are the people who are there long-term, and they are not there for rehab. They are not really being treated medically. They are just being provided care because they're too old, they're too sick, they can't take care of themselves anymore, and they need that skilled nursing level of care. So when you come into the rehab facility from the hospital, Medicare does pay for that while you are rehabbing. What a lot of people don't understand, and they find out very abruptly and are shocked to find out, is that once your doctor has determined that you are no longer needing rehab, in other words, you're not improving anymore, they've gotten you as improved as they're going to get you, then Medicare stops paying. And then if you still need to stay there in the nursing home because you really aren't well enough to go home, you are going to be paying privately. You're like right out of your checking account, you're going to be paying. And I probably don't need to tell anybody here, but nursing homes are very, very expensive. $12,000, $14,000. I've had clients paying $21,000 a month for nursing home care. So that's a rude awakening when the facility comes to your family and says, well, Medicare isn't covering this anymore. Another thing about Medicare, Medicare covers, even if you're still rehabbing and Medicare is covering it, they only cover it fully for 20 days. After the 20th day, if you are still there and still rehabbing, you have a copay, and your copay is $185.50 per day. And Medicare will pay the rest, but that's a pretty stiff copay every day for the rest of your stay there. So the other thing about Medicare, it only pays 100 days maximum, regardless of why you're there, what you're there for, 100 days maximum. And then again, you're on private pay. Medi-Cal will pay for people to be in the nursing home who need skilled nursing care. They're over the age of 65. If they are eligible for Medi-Cal. And we're going to talk about what that means to be eligible for Medi-Cal. So that's kind of important to understand the difference between Medicare and Medi-Cal so that you don't make that mistake as well. The next common misconception is the difference between assisted living and skilled nursing. Most people who have never had a parent who's elderly and in need of long-term care or some other relative, most people really aren't familiar with this world of skilled nursing, assisted living, board and care. All those terms are just foreign to most of my clients when they first meet with me. And we have to spend a lot of time educating them about what things are out there, what things are available for their particular situation. So you probably all are familiar with some of the large assisted living facilities around town, like the Kensington, Atria, Byron Park. Those are assisted living facilities. People go there because they need some help. There are certain things in their lives that they can't really do very well anymore. And they go because it's a big facility, there's social things, and they can make friends and have a community. That's assisted living. Medi-Cal doesn't pay for that. Medicare doesn't pay for that. That's all private. Also, under the umbrella of assisted living are the boarding care facilities, and those are the small, they look like a house. They're in your neighborhood. You wouldn't know it was a board and care, except maybe there's a wheelchair ramp out front. And those usually have 6 residents in them. That's boarding care. That's also assisted living. Therefore, Medicare doesn't pay for it. Medi-Cal doesn't pay for it. The thing that I find is the most troubling for my clients is memory care. So dementia is a huge problem right now. I have almost all of the clients who I work with on Medi-Cal planning, the issue is dementia, almost always. And the thing about dementia is that it oftentimes is not until very late in dementia that someone actually needs skilled nursing level of care. In order to get into a skilled nursing facility, your doctor has to say you need skilled nursing level of care. And people can live for a long time with dementia and not be able to take care of themselves, not be able to keep themselves safe, and they really need to go into what's called memory care. But memory care is assisted living. And again, if you remember what I've been saying, Medicare doesn't pay for it, Medi-Cal doesn't pay for it. And that is very, very hard for a lot of families. And so you just have to be aware of what the options are there. When we're talking about dementia, it's not until more advanced stage where the person actually needs skilled nursing that we can start talking about Medi-Cal. Okay, so my next misconception, many people are under the misconception that in order to qualify for Medi-Cal, you have to get rid of all your assets. And that simply is not true. And the law under Medi-Cal says that there are certain assets you can have and still be able to get Medi-Cal to help pay for nursing home care. Those assets are called exempt assets. That's the term that we use. And I have them up here on the screen. The exempt assets, the most common exempt assets, there are some others that are obscure, but the most common ones are up here on the screen. You can own your home of any value. You can own one car. You can own your tangible personal property. In other words, the contents of your home, the furniture, the clothing, the books, the artwork. Your spouse can own an IRA or a 401k or multiple IRAs. You can have a small permanent life insurance policy, and you can have $2,000. And if you're married, your spouse can have $130,380. So that's basically the total of what you can have that's called exempt assets. There are some other assets that are called non-exempt but unavailable, and therefore they're treated like exempt assets. And those include your IRAs and your 401ks and certain kinds of annuities. Now, you notice the distinction between your spouse's IRA is an exempt asset. Your IRA is a non-exempt but unavailable asset. So neither one of them will prevent you from qualifying for Medi-Cal, but they're just treated a little bit differently. Anything beyond that will make you ineligible for Medi-Cal. So for example, if instead of $130,000, your spouse had $200,000, you would not be eligible for Medi-Cal just yet. So that's where the planning comes in, and we've got to figure out how are we going to get to that point. Okay, so the next common misconception, Medi-Cal facilities are terrible. I hear this not so much from my clients, although once in a while, but I hear this just when I'm out in the world talking to people, and they'll say something when they find out that I help people with Medi-Cal planning. They say, oh, you know, my mom is in assisted living, and I just would never put her in a Medi-Cal nursing home because they're just terrible. And I did some research not too long ago. The US government on one of their websites, medicare.gov, it has a nursing home search function, and you can put in your zip code and you can put in your radius and you can search for nursing homes. So I put in my Walnut Creek zip code and I put in 25 miles. I want to find all the nursing homes within 25 miles of my Walnut Creek office. And it came up with 118 nursing homes. And then I did that same search, but I clicked one more button, and that button was accepts Medi-Cal. So now we're searching the same area, but we're only searching for nursing homes that accept Medi-Cal. The first time around, it came up with 118. The second time around, it came up with 109. That's 92% of the nursing homes accept Medi-Cal. I did it again for Orinda. I used the Orinda zip code. Same thing, 91%. And I live in Oakland, so I thought, okay, I'll do it for Oakland. Did it for my Oakland zip code. Same thing, 91%. The vast majority of nursing homes are Medi-Cal nursing homes. They accept Medi-Cal. And the reason for that is that if a nursing home wants to be able to get Medicare patients, those rehab patients who are coming from the hospital, they have to also accept Medi-Cal. And those rehab patients is where they make their money. So most nursing homes really want to be available for Medicare people, and therefore they have to be available for Medi-Cal. So when a nursing home tells you, oh, we only have 10 Medi-Cal beds, that's never true. That's never true. All their beds are Medi-Cal beds if they take Medi-Cal. So I think that when people say Medi-Cal nursing homes are terrible, what they really mean is nursing homes are terrible. And that may be true, that most of us would not choose to live in a nursing home. Sometimes we have no choice. But I just like to clear up that sort of myth. I like to debunk that myth. Okay, so my next common misconception is that Medi-Cal planning takes 5 years. You have to plan way ahead. And a lot of people have heard that number, 5 years, and it does exist somewhere in Medi-Cal law, but it doesn't mean that you have to plan 5 years ahead, and that if you didn't start planning 5 years ago, it's too late for you. California is the single most generous state when it comes to Medi-Cal in terms of how easy it is to become eligible. every other state in the country has a different set of laws than we have in California. We are the last ones. We are the last holdout. The law got changed in 2005, I believe, and everybody else has had to adapt and take on the new federal requirements, and California just has never done it. So we're still operating under the old law, and we will until, you know, the legislature decides to change it. And so it's very much easier in California to become eligible for Medi-Cal to pay for nursing home care when you're over 65. That 5-year number is what we call the look back period. So when you submit your Medi-Cal application, they will ask you, what gifts have you made in the last 5 years? They're going to look back for 5 years, and you have to tell them about all the significant gifts that you've made. Now, you're not going to tell them, you know, that you gave your grandson a Tickle Me Elmo doll. That's not what they're talking about. But if you gave one of your children $5,000, you know, something significant, you have to disclose that. That's the look back period, and they want to know that. So that's where that 5-year number came from. But it doesn't mean that you're not going to qualify for Medi-Cal because you gave assets away during the 5-year period. We just have to disclose it. The reason they want to know what you've given away in the last 5 years is that when you give your assets away in order to qualify for Medi-Cal, you can be penalized for doing that. And I say that carefully because the penalty is pretty easy to manage. It's pretty easy to plan around, but it's still called a penalty. And I'm going to give you an example. Let's say, remember on a couple of slides ago, I had that list of exempt assets. The assets that you can have still qualify for Medi-Cal. So in my scenario, if we had $100,000 too much, we would have to give away $100,000 in order to qualify for Medi-Cal. Okay, so we could write a check for $100,000 and give it to one of our children. We could do that, and then that $100,000 would be gone. But we would have to disclose that in our Medi-Cal application, and the way that Medi-Cal penalizes us is there is a number called the APPR. You don't have to remember that. That number is approximately $10,000. It's a tiny bit more. And I'm going to just pretend it's $10,000 because I can do that math in my head. If you made a gift of $100,000 and the APPR is $10,000, we divide your gift by the APPR. 100,000 divided by 10,000 is 10. So you've applied for Medi-Cal, you're eligible for Medi-Cal because you're in a nursing home and you don't have excess assets, but you're going to have a 10-month penalty. So even though you're eligible, you're not going to start receiving your Medi-Cal for 10 months. Now, if we use that same scenario, we have $100,000 too much. And instead of writing a $100,000 check, I write a $50,000 check to one child and a $50,000 check to the other child. Each of those is a $50,000 gift. So when we divide 50,000 by 10,000, the number we get is 5. So we only have a 5-month penalty, and all the penalties on each gift run at the same time. So you can, I think, imagine how easy it would be to just do the math and figure out a way to make the gifts that add up to $100,000 and won't result in hardly any penalty. And that's part of the planning. So the idea that we've got to do this planning 5 years ago is just not true. I've had clients who within a couple of months of hiring me are eligible for Medi-Cal, and then 2 or 3 weeks later they're on Medi-Cal because we submit the application. So it really doesn't it really doesn't take very long at all if you do the planning correctly. And one other little fact is that, as I said, Medi-Cal can penalize you for giving assets away. The maximum penalty under California law is 30 months, so 2.5 years. I've never done planning for someone who got a 2.5-year penalty. It's almost not worth doing the planning if you're going to get that big of a penalty. So we always go for a very, very short penalty period when we do our planning. Okay, another misconception is, this is a big one, about the timing of the Medi-Cal application. We do not submit the Medi-Cal application until you are eligible. And what you have to establish to be eligible is you have to need skilled nursing care. So a doctor has to say you need skilled nursing care. You have to actually be in the skilled nursing facility. We don't apply until you're actually in the skilled nursing facility, because if you're not in there, you don't need Medi-Cal and they won't give it to you. And then you have to qualify on the income and on the assets. And those are the things that we do planning around. But it's important, and most people don't realize this, that we don't apply until you are actually in the skilled nursing facility. That's maybe one of the most common misconceptions. So you've got to be eligible before we even apply. And so thinking back to that slide where I showed you all the exempt assets, we got to make sure we fit into that template, that we don't have any extra assets before we apply. Now I've got just a couple of more concepts. These aren't misconceptions, they're just a few more concepts to go over with you, so that you can get the whole picture about Medi-Cal planning. This first one is called share of costs. When you are in a skilled nursing facility and Medi-Cal is paying for you to be there, typically you will have what's called a share of costs. That means you have to pay for some of your care and Medi-Cal will pay the rest. And how they determine that is it's based on your income. If let's say your income is $2,000 a month, that's Social Security, and that's your entire income. Your share of cost is going to be $2,000 minus $35. Medi-Cal allows you to keep $35 every month, so you can, go wild, go nuts with your little $35 allowance. They figure that you probably need to buy toothpaste and shampoo, but the rest of your income will go toward paying for the nursing home care, and Medi-Cal will pay the rest, and that's share of cost. Your spouse's income, if you are married and you are in a nursing home and Medi-Cal is paying for you to be there, your spouse's income is irrelevant. Your spouse gets to keep his or her income. They are not required to spend their income on your nursing home care. Now, sometimes we get into a situation where the spouse going into the nursing home is the one who has most or all of the income. There are older couples where the husband typically worked and had a career, and so his Social Security check is $3,000 a month, and his spouse's Social Security check is much smaller because she didn't work for as many years. And so if we put the spouse with the high income into nursing home on Medi-Cal, and all that income goes toward paying for the nursing home, the spouse at home has not enough money to live off of. So there is a way under Medi-Cal for a big chunk of the spouse who's in the nursing home, a big chunk of their income to go to the other spouse. If the other spouse's income is too low, then the share of cost gets adjusted so that the other spouse can keep some of the income. But that's the only way in which the spouse at home's income is relevant. The spouse at home can be earning $20,000 a month and it doesn't matter for Medi-Cal eligibility. Okay, and the last concept that we need to understand when we're doing Medi-Cal planning is estate recovery. When you receive Medi-Cal benefits during your lifetime and then you die, the Department of Healthcare Services sends your family a bill. And the bill is for all of the medical care that you received under Medi-Cal during your lifetime. And, you know, depending on how long you were on Medi-Cal, if it's several years, and which is not uncommon in a nursing home for several years, I've seen those bills be $160,000. It can be quite a bit. And they are entitled to be paid back. However, there are restrictions on what they can get. So they are entitled to be paid back from what's called your probate estate. That means anything that you own in your own name on the day you die, that's considered your probate estate. So for example, if you have a checking account in your name, when you die, that's part of your probate estate. And if there's anything left in that checking account after we pay for your funeral, after we pay your final expenses, Medi-Cal could go after that and be expected to be reimbursed out of that. However, most people in California are aware that we are always trying to avoid probate. That's what I do for a living, is I help people avoid probate. And we do that by setting up estate plans that include a revocable living trust. If you own your assets in a trust when you die, rather than in your own name, those assets are not part of your probate estate, and therefore they're not subject to estate recovery. And one other thing is, even if you do own certain assets in your own name on the day that you die, if you are survived by a spouse, the state will not be able to get recovery against your estate while your spouse is alive. After your spouse dies, they will. And so, you know, again, the solution to that is to do an estate plan, have a revocable living trust, just don't have any kind of probate estate, don't have any assets lying around outside of your trust on the day that you die. Also, if you are survived by a blind or disabled child, there won't be any Medi-Cal estate recovery. But those are things that we can't necessarily control. We can control, do you have an estate plan? And sometimes people come to me thinking they need to do Medi-Cal planning, and they don't, because their assets are already below the threshold. But we have to make sure, absolutely sure, that they have an estate plan in place so that there won't be any estate recovery. So sometimes that's what we're doing. Okay. Now I've covered all those, and you should be at this point ready to start thinking about, how do we actually do this eligibility planning? We're working with our client who is in a skilled nursing facility, can't really afford to keep paying for that for the rest of their lives, but they have too much assets. So think back to that slide with the exempt assets, the house, the car, the 401ks, the IRAs, and the $2,000 for the Medi-Cal spouse, the $130,000 for the other spouse. What do we do? How do we go from what we have? And we'll use my same scenario. We have $100,000 too much. How do we deal with that $100,000 so that we get back down to the threshold we want to be at? One very easy and common way is to convert our non-exempt assets to our exempt assets. So that extra $100,000 is a non-exempt asset. We're not allowed to have it. But what do we have that is an exempt asset that we could use that money for? Well, we're allowed to have a car. Maybe we need to spend some of that money buying a new car, a better car, a more expensive car. Also, we're allowed to have a home. Maybe our home has a mortgage on it, and maybe we can use some of that $100,000 to pay down the mortgage. That's okay. We're just taking non-exempt money, putting it into an exempt asset. Or maybe the home could use some repairs or improvements. Maybe it needs a new roof. Maybe it's a good idea to start putting grab bars in, to start modifying things for the spouse who's going to be staying at home. There are ways that we can take that extra money and spend it in the home and turn the non-exempt asset into an exempt asset. For a lot of our clients, though, that's not really going to work. It's not going to take care of all of the money. And so we do have to do some gifting or giving away. And remember, in the previous scenario, when I was talking about giving away that $100,000, we want to make those gifts small enough that we can manage the penalty period. And there are two different ways to do gifting. One is just an outright gift. I sit down and write a check to my son and I give him the check. That's just an outright gift. Here you go, take this, now it's yours. In my practice, that makes me very uncomfortable. I don't want my clients giving their children large sums of money because it's all the money they have. So typically we will set up an irrevocable trust to receive the gifts. The irrevocable trust is a trust that the client who's going to be receiving Medi-Cal cannot be a beneficiary of, they cannot be a trustee, but that money is there, it's safe in a trust, and we can get the money out when we need it. So that's my preferred way for doing gifting for Medi-Cal planning, is to use an irrevocable trust. The last example I have up here, converting assets to income, I don't personally use that. I know some people do use that. When you purchase an annuity, probably everyone in this room's got some familiarity with annuities. You take a large chunk of money and you purchase an annuity, and what you get in return for your large chunk of money is an income stream. Every month you're going to get a check from this insurance company. And so that, you're taking these non-exempt assets and turning them into an unavailable non-exempt asset, and therefore something that doesn't count against you. I don't like it because it's very hard, and you get penalized if you actually need to take the money back out for some reason. So I tend to shy away from annuities for that reason, but I know some people like to use them, and so that's just a difference of opinion. Okay, so now I am going to bring Susan back and we'll start answering questions.
Great. Thank you for that. That was very helpful even for me. We have one question so far, and the question is, do you ever recommend divorce as a way to become eligible for Medi-Cal?
I will say that I personally never do recommend that. I know people have done it, and I've had clients ask me, do you think that we ought to just go ahead and be divorced? I don't know that really gets you anywhere that we can't get you without just doing Medi-Cal planning. And so just on principle, I have a hard time recommending that to somebody. And I would say, sometimes that comes up when there's a spouse who's actually incapacitated and the other spouse is wondering, maybe we should just get divorced. I think that would be a very difficult situation. It would be very difficult to divorce a spouse who's incapacitated and not get a spousal support order that forces you to spend your money anyway. Judges, I'm guessing, would not like that you're going to leave your spouse in a nursing home and not pay anything and just walk away with all the assets. So yeah, I never do. I know some people do it, but I don't.
Okay. There is no other question. So, and if people do have questions, they can submit questions for the next Q&A after the special needs planning. And I will let you continue on with your program. Thank you.
All right. I think I have to re-share my screen. Okay. Okay, I hopefully I did that. So thank you all for bearing with me here. Now, we're going to now be talking about special needs planning, which is in a way related to the Medi-Cal for nursing home planning, in that Medi-Cal is a factor in special needs planning, and also, you know, with both populations, we are talking about disabled people. So in a way, they're kind of related, but they're different. They're different. The typical scenario when we're doing special needs planning is we are working with parents on their estate plan, and the parents have a disabled child. And as part of their estate plan, they need to plan for what's going to happen with that child after we pass away. And the child is disabled. The child is not going to be able to work enough to support him or herself. So there's sort of an additional level of planning that we have to do from just a conventional estate plan. And I would say that the need to do financial planning is also pretty high for those families. They need to generate a lot more wealth in order to be able to take care of that child after the parents pass away. So oftentimes we're talking about life insurance for them. We want to make sure they've got life insurance. For a disabled person who cannot support themselves, there are basically 3 buckets of resources available. There's the unpaid friends and family who can provide care. And that's what the parents have been doing all through this child's life. The parents have been caregivers. They've been helping. They've been doing all the things that needs to be done to help that child. So that is great while the parents are around, but that's really not a sustainable model for the long term after the parents die. The other bucket is going to be just savings and income. And again, the parents during their lifetime, that's what they've been providing to this child. They use their savings, they use their income to pay for whatever the child needs. They let the child live in their home, or they pay rent for the child. They buy food for the child. They pay for the doctor visits. All of that is coming from the parents. And then the third resource available to this disabled child is going to be government benefits. So when we're doing special needs planning, we are recognizing that we're going to have to replace the parents. We're going to have to replace the unpaid family and friends. We're going to have to replace the parents' savings and income with estate planning. And in order to do that, we also want to avoid disrupting the government benefits that the child is receiving, because those can be very, very valuable. So you envision that the parents are going to die, they're going to leave an inheritance for this child. And what are we going to do with that so that we don't disrupt these government benefits that the child is receiving? that's what special needs planning is about, is making financial resources available, financial resources as in an inheritance, to provide the best possible life for the disabled child without disrupting government benefits. That, you know, in a nutshell, is what special needs planning is. Now, in the world of disability, there are two basic types of government benefits. There are the needs-based government benefits, and then there are the entitlement benefits. An entitlement benefit is something that you qualify for just because of your status. And up here on the screen, an example of an entitlement benefit is Medicare. So we're all familiar with Medicare. Medicare, when you turn 65, you get Medicare. You don't have to prove that you have low income. You don't have to show anybody your statements for your bank accounts. It doesn't matter. You're entitled because you turned 65. So that's an entitlement benefit. Another entitlement benefit is SSDI, Social Security Disability Income. People who become disabled can qualify for this benefit, SSDI, if they meet the Social Security Administration's definition of disabled, and if they have paid into Social Security sufficiently. So in other words, they have had a job in the past. Typically, our special needs children would not meet that criteria. They are disabled, they meet the Social Security Administration definition of disability, but they don't have the job history, so they can't get SSDI. They get instead, if they're eligible, SSI, Supplemental Security Income. And those two things look very similar. SSI, SSDI, they both come from Social Security. Clients get them confused all the time, all the time. Clients who are receiving these benefits don't even know what it is they're receiving sometimes. But SSI is a needs-based benefit. You have to prove that you financially need SSI. And Medi-Cal, as we've been talking, Medi-Cal is a lot of things, but in this realm, it is also a needs-based benefit and not an entitlement. It's a little bit different from the nursing home requirements, but we'll talk about that in just a minute. Okay, so Medi-Cal is a joint federal and state program that helps people with low income. So people who are disabled, have been disabled all their lives and unable to work, they would be eligible for that. SSI is actually a cash benefit. The maximum in California is $945.72 a month. It's not a huge benefit. It's meant to pay for food and shelter. It's very subsistence level, and probably nobody in this room could imagine that you could get food and shelter in Walnut Creek, California for $954 a month. But that's what it is. And not everybody gets the maximum benefit. Some people get less than that, and we'll talk about that in a little bit. Okay, so as I said, the SSI benefit is really not that big. It can make a difference. I'm not saying it's nothing, but it's really not that big. What's big about it is that if you qualify for SSI, you automatically qualify for Medi-Cal, and Medi-Cal is a big benefit. It pays for healthcare. It pays for all of your healthcare. If you were unable to work, you didn't have a job, and you had to pay for your own healthcare, you just couldn't do it. So being eligible for SSI, sometimes the money benefit is not as important, but it's very important to keep that SSI so that you can qualify for Medi-Cal. So sometimes people will have income and their income reduces their SSI benefit. We just want to manage it and make sure we don't reduce that SSI benefit to zero. because as long as you are receiving at least $1 in SSI, you will qualify for Medi-Cal. And that's usually the benefit that we worry about the most when we're talking about special needs planning. Okay, so how do we qualify for SSI? First of all, as I said, you have to be disabled. You have to meet the Social Security Administration's definition of disabled. Secondly, your resources have to be below a certain threshold. And it's very similar to the list of exempt assets that I talked about earlier when we were talking about Medi-Cal planning. You can have a home, you can have a car, and you can have $2,000. Those are the basic resources that still enable you to receive SSI. And then your income has to be below a certain threshold in order to qualify. Now, there are a lot of very complicated rules around income and what you can have and what you can't have and how much it reduces your benefit. You can have income and still qualify for SSI, but it reduces the size of your benefit. And so back to my typical special needs planning scenario, the parents who are doing estate planning with a disabled child. If they anticipate that this child is going to have, let's say, an inheritance of $500,000, you can see by looking at this slide that that's going to be a problem. When that child inherits $500,000, well, that's a lot more than $2,000. That means the SSI goes away and the Medi-Cal goes away. And that's not what we want. We want to prevent that. So what do? We set up a special needs trust, and it's instead of the child inheriting $500,000, that $500,000 when the parents die goes into the special needs trust. The special needs trusts are recognized by state and federal law, and they are not counted as a resource when we're trying to figure out if you're eligible for SSI or not. They are not counted. They are, in essence, an exempt asset. So the special needs trust allows the trustee to use the child's inheritance to pay for things that the child needs without jeopardizing the SSI or the Medi-Cal. That's so important to this child. There are complicated rules about income, so our trustee has to be very careful when making distributions from this trust, not spending it on the wrong things, not giving money to the beneficiary, the special needs person. They just need to follow the rules in order to avoid jeopardizing that benefit. Now, I've been talking about the typical scenario, which is parents are coming in, they're doing estate planning, they want to set up a special needs trust for their child for when they die. That is the most common scenario that we deal with. In that situation, we are planning for protecting the parent's money in a special needs trust. But sometimes when we're working on special needs planning, we have a disabled person who has their own money. And what we want to do is protect that money so that they can keep that money and still keep their government benefits. So those are two different kinds of trusts. When we're doing a special needs trust with somebody else's money, that's called a third-party special needs trust. When we're doing special needs planning with the disabled person's money, that's called a first-party special needs trust. So how would that happen? Most commonly, it's a lawsuit that the disabled person sued somebody and they got a bunch of money. Or it could be an inheritance where the family did not plan ahead, they did not set up a special needs trust, and all of a sudden this disabled child inherits $500,000. Then we've got to create a first-party special needs trust and put that money into the special needs trust. Now, the first-party special needs trust is great but the third party special needs trust is way better. And the first party special needs trust is kind of, okay, we got to fix this problem. Third party special needs trust is we are planning ahead and we're being proactive and we're doing it right. So that situation with the child inheriting money, it can be saved, but it's not as good as planning ahead. Okay, I think that end of that one. So there's a few concepts when we're doing special needs planning that are a little bit different from what you might be familiar with. If you're sitting here in this audience and you have your own estate plan, you have a revocable trust, you have an understanding of what I hope that trust says and what it does. There are a few things that we do a little bit differently in a special needs trust. So one of the things is we have to talk very frankly with the parents about the trustee. It's so critical with a special needs trust to pick a good trustee. And many parents come in with the idea that their other child should be the trustee of this special needs trust for their sibling. So two siblings, one's the special needs child, the parents want the other one to be the trustee. And I try very hard to talk them out of that. That is not a good situation for the trustee child. This is a lot of work. It takes a lot of time. And the trustee child has their own life too. They're gonna have a family, they're gonna have a job, they've got things to do. And to have that burden of being the trustee for the sibling, it's kind of a lot to ask. So I try to talk clients out of it. The other thing, the trustee has to understand these special needs laws and not do things that will jeopardize the benefit. It takes, in my opinion, the best solution is a professional trustee. There are people who do this for a living. They get paid, but they know what they're doing and they don't make mistakes. So that's my recommendation. Another position that we have in a special needs trust usually is called a trust protector. And usually what we do with the trust protector is we give them two jobs. Their first job is they can fire the trustee and they can hire a new trustee. They can remove a trustee who's not doing a good job or who's become elderly and really can't do the job anymore, or if a trustee dies, they can appoint a replacement for the trustee. And that's really important because a lot of times a special needs trust is going to last a long time. It might last 30 years, 40 years. So we really need that kind of flexibility to be able to keep an eye on the trustee and put a new trustee in if we need it. The second job that we give to the trust protector usually is we give them the ability to modify the trust if we ever need to do that. As I said, these trusts sometimes last many years, and the law is always changing. So if we get to a situation where the trust just doesn't work anymore because the law has changed, we need someone who can legally change the trust. And that is the job that we typically give to the trust protector. And one more person or group of people that we oftentimes include in a special needs trust is a trust advisor or advisory committee. And these are often friends or family members who really know the special needs beneficiary very well. They've known him or her all their lives. And this is most important when we have a beneficiary who's perhaps not verbal, who's not able to speak for themselves. The trustee is trying to do their job, but maybe they don't know this beneficiary. If they're a professional trustee who is just hired to do the job, it would help them a lot to have friends and family members who they can rely upon to share information about the beneficiary who can't speak for themselves. So oftentimes we will include in the special needs trust a provision for a trust advisor if it's just one, or an advisory committee if we have a group of family members who are willing to do that. All right, and now I am turning it over to Susan to ask more questions.
Great. Thank you, Kirsten. Before we get to the questions for this portion, there was one question from the Medi-Cal portion.
Okay.
A question from Jacqueline. What if all assets are jointly owned by a married couple? Do you assume that 50% is owned by the person who needs the nursing home care?
Well, yes and no. So on the Medi-Cal application, it doesn't matter. If they're jointly owned, you gotta put them all on the application, and then once your application is granted, in other words, once you are eligible for Medi-Cal, that's when you've got to move the assets from one spouse to the other so that you have that configuration I was talking about. $2,000 for the spouse in the nursing home, $130,000 for the other spouse. So it doesn't really matter how they're owned. Everything the couple owns, whether jointly or singly, goes on the Medi-Cal application.
Thank you. And then one question we had for this portion, can a special needs trust buy a house for the beneficiary?
It's a good question. Yes, a special needs trust can purchase a home. One of the sort of caveats about that, and it's not a deal breaker, but you just need to know, is that, remember, SSI, the supplemental security income, which is the benefit that we're kind of concerned about in special needs, is meant to pay for shelter and food. And so if somebody other than the SSI recipient is paying for shelter, the SSI benefit is going to be reduced a little bit. It won't be completely reduced, but so in other words, if you buy a house in a special needs trust and you don't charge rent to the special needs person, you're providing them free shelter, and that will reduce their SSI benefit. But yes, you can do it, and a lot of people do that.
Thank you. So folks are also wondering if it's possible to get a copy of your presentation, the PowerPoint slides.
Yeah, absolutely. How do you want to do that?
Yeah, if you send it to us, everyone who has registered for tonight's program will receive a link to the video recording of this program, so you can watch it again because it's chock full of information. And we will also include your presentation in that, the attachment in the email. And that is all. So thank you so much for your presentation, Kirsten. It's been very helpful, and we appreciate you being part of our Finance 101 series.
Thank you. I enjoyed it very much, and I hope to do it again in the future.
So I just wanted to thank everybody else who joined us tonight. If you enjoyed tonight's program, we look forward to seeing you at the next one, which is our final program on April 22nd. And tonight's program is a perfect segue to it. We'll be talking about Social Security and Medicare, Get What's Yours. We learned about Medi-Cal tonight, and you can join us to hear about Medicare and Social Security. We also asked if you enjoyed tonight's program to make a gift to the Walnut Creek Library Foundation. You can click on the donate button on our website at wclibrary.org or in the chat box, and know that your gift makes a difference. We thank you again for attending, and good night.